Hey there, the 14 questions your estate attorney must ask. Okay, this is a big one because I've had thousands and thousands of these prospective clients have conversations with me. I'm in these Zoom calls all day with people all over the country who have requested, I have them guide them through the estate planning process. And I've had a lot of people tell me, Paul, I've talked to other lawyers before, and I don't want to knock all the other lawyers, but just I'm telling you what some people tell me is they'll tell me that the lawyer just liked to hear himself talk, or the lawyer talked over my head, just talked in terms that I had no idea what he meant. So this first conversation that you have with the estate planning attorney, it's real important, and there's the questions that they have to ask you. And I've titled this the 14 questions your estate attorney must ask. That is an absolute minimum, and you're going to see as we go along. Sometimes I'll ask a question, and then as I listen to the answer to that question, well, that triggers a whole nother string of questions I have to ask. But I put 14 that they absolutely have to be asked in every situation. But yes, again, I don't want anybody coming back to me on the comments of surely a lawyer should ask this question too, because this is just bare bones. Okay. Now, let's just jump right in. So we're going to assume this is a married couple. Yes, lots of unmarried people plan their estates, but I've dealt with thousands of people, and I'd say the majority of my initial client conversations have been with married couples. In fact, most of the time they're in their 50s or 60s. Yes, I've done this for people in their 70s and their 80s and their 90s, and I've done it for people in their 20s and their 30s and their 40s. But it seems like it's in that 50s to 60s is when people really get serious. They're like, boy, we really have to get our affairs in order. We're not going to live forever. So that's kind of in my mind. I'm envisioning as I go through this video, I'm asking questions of maybe a 60-something-year-old married couple. But you can modify these questions if you're younger or older, or if you're unmarried. So let's just jump right in. One of the most important questions, I'll put it the first one, because really I kind of ask these questions in this order. So let's go through it. Number one, question I ask is, what do you want to make sure you accomplish as part of getting all of your legal affairs in order? And if I said it another way, it might be, what do you want to find out? What do you want to make sure gets addressed? But really it's important that if you're going to be talking to an estate planning attorney and there is something on your mind that you want to make sure gets addressed, it's pretty important that you let that attorney know up front what that is. So when I ask, what do you want to make sure you accomplish? I get a million different answers. Some people might say, well, we want to leave something to our grandchildren. Some people say we did a lot for this child, and so we want our other children to inherit a little more because we did for this child. Other people say, I want to make sure all these tax consequences are minimized or avoided. Some people say, I just want to make sure my spouse is taken care of. If I die before my spouse, I don't want there to be any difficulty. Some people say, I want to keep things simple. Some people come out and say, I want to make sure probate gets avoided. So there's an unlimited number of answers that are possible to the, what do you want to make sure you accomplish? Some people have said, I want to make sure my vehicle goes to my grandchild, and that was the most important thing to them. So it's inappropriate and wrong for the lawyer to make these assumptions as to what's important to you. So I like to just, ask that open-ended question. What do you want to make sure you accomplish? Some people have a list of maybe 4 or 5 things. Some people say, well, I don't know enough to know. And so that's when the lawyer's job is to kind of guide them through the questions and start pulling information out of them. So first, question 1 of 14, what do you want to make sure you accomplish? Question number 2, I'll tell it to you this way in the video, kind of, what's your family tree? And that's not really the right way. Or what's your family circumstances? I'm not really looking into who are your grandparents, who are your great grandparents. That's probably irrelevant, unless of course you're expecting some large inheritance from your grandparents or your parents, and that might impact your estate. But really, I'm looking at, okay, are you married? Do you have any children? Do you have any grandchildren? Sometimes it comes out that maybe one of the spouses had children from a prior marriage or a prior relationship. So the lawyer needs to know, okay, are there children, are there grandchildren? Because you're probably going to be leaving things to your descendants, and we need to know who those descendants are. Need to know, are they young? Are they children? Are they adults? So need to know that family tree. I always take out a legal pad and I'll put John and Jane at the top, and then if they have three children, I'll three branches and list those children's name as I'm taking notes, so I can kind of refer to those people as we go through the process, because they're going to be involved in the estate plan typically. So that's number two. What's the family tree look like? Number three, and maybe I don't ask this up front, but usually it comes out pretty quick, and usually everybody's kind of more than willing to share this information, although they may not share it with their friends and their acquaintances. It's what's the value of your estate? Certainly helps me as an estate planning lawyer to kind of know that net worth that you have. And yet it's an absolutely necessary question when we have to address planning around the federal estate tax, which is affecting fewer and fewer people these days, because for people who pass away in 2025, the first $13.99 million in their estate is exempt from the 40% federal estate tax. And in 2026, the exemption increases to $15 million per estate. Many married couples mistakenly assume that it's a flat $15 million for the married couple. However, if you put the right planning in place and have everything structured right, have all the documents right, make all the appropriate decisions after the first spouse dies, pretty simple for married couples to exempt two times that estate tax exemption, because each spouse or each estate in 2026 will have a $15 million exemption. So for the married couples, it's really $30 million that is exempt from the federal estate tax. Yes, I've helped many people with more than $30 million, but the majority of people that I help have less, and the majority of them have far less than $30 million estate for a married couple. So that's one reason why the question needs to be asked, and what's the value of the estate. But the other reason I think that I need to know that answer is, it just gives me some context. Are the children going to be inheriting, $300,000, or are they going to be inheriting $4 million each? And kind of when I know roughly what that estate looks like, I can kind of do some quick math, see what the children, maybe the grandchildren, are inheriting. And, that gives me an idea, because from an estate planning perspective, we might treat a $100,000 inheritance different than a $4 million inheritance. And so more to lose when you leave someone a $4 million inheritance, or more for them to lose. So it helps if I know all that. What's the value of your estate? That's question number three. Question number four, what kind of assets make up your estate? Again, because it's important for me to know that, because different assets get handled differently as part of the estate planning process. Some people have the majority of their net worth in their IRA, their retirement account. Their will or their trust has nothing to do with who gets their IRA when they die. That goes by beneficiary designation. Some people have family businesses or family vacation homes or family property that they want to make sure gets handled a certain way after they pass away. Some people want to make sure that it kind of stays in the family. Other people have cash. Other people have investments. So need to know generally what's the makeup of what you have. Some people have rental property, and then we need to know whether that rental property, whether it's commercial or residential, is it owned by you? Is it owned inside of an LLC? All those kind of, what does your estate consist of, and what's the makeup of your estate, is an important question that just an estate planning attorney needs to know to be able to customize and develop, that comprehensive plan that accomplishes everything that you're trying to accomplish. All right, so that's kind of the beginning. What do you want to make sure you accomplish? What's your family tree look like? What's the value of your estate, and what's the makeup of what you have? Now we get into when something happens, questions. I like to start at the end and work my way backwards. And so the first question that I ask is, what happens at the very end, or what happens after, for a married couple, what happens after you and your spouse pass away, because most married couples, they're thinking in their mind what's going to happen after both the husband and the wife pass away. Yes, it's really important to address what happens when the first spouse passes away. In fact, that's one of our questions, but I like to start at the end and work backwards. So the question when it comes out of my mouth is something like, okay, let's start at the end and work backwards. Let's first talk about what happens after both of you pass away. And I might go ahead and further say, and I'm talking about not only in the unlikely event that you both pass away at the same time, but I'm also talking about, when one of you passes away and then the survivor passes away perhaps years later. So you're both gone. And how do you want things to go? And that kind of starts the conversation. And so sometimes I get some clarifying question like, you mean we both died? And so I'm like, yeah, you're both gone. So let's just, think in your mind, something happened to both of you tomorrow. How would you want things to go? And so what I'm trying to get at is, do they want things to go equally to their children? Do they have some thoughts in their mind about maybe they'd like to carve out something for the grandchildren if they have grandchildren? Maybe they want to leave some specific bequest to individuals or to charities. Maybe they did some things for certain children during their lifetime, but not for the other children because the other children didn't really need it. So they want to use the inheritance to kind of equalize things. Sometimes people will tell me, well, we have a child or children who can't handle money. So that's why we want to make sure it gets managed for them. What do you want to happen after both of you pass away? That's when all of this kind of comes out. And of course, every answer somebody gives me may trigger another 3, 5, 10, 20 questions. So, really it's the lawyer's job not to speak the whole time, but to ask the right question and then listen to the answer so that the lawyer can ask the next right question. I heard a saying sometimes people have 2 ears and 1 mouth. So when you're in, you ought to be listening about twice as much as you're speaking. And I think that's appropriate for the estate planning attorney as well. All right. So what happens after both of you pass away? And so, do you want to leave it to the children equally? Is something that's there may be a reason why you do not want to leave things equally, and we can have that conversation. So again, our job to make sure that you accomplish what you're trying to accomplish. And so after we have that kind of initial answer to the what do you want to happen after both of you pass away, probably worth another question. Do you want to kind of carve out anything? So most people may start with that. What do you want to happen after both of you pass away? Start with well, we'd like to leave things equally to our 3 children or whatever it is they have. And by the way, if it's a blended family, maybe it's, the husband's part goes to his 2 children after both the husband and wife pass away, and the wife's part goes to her 3 children. Maybe it's something like that. So it's the attorney's job to let them know what those options are and make them feel comfortable with making the decision that is right for them. And then if they do have if they do have grandchildren, question number 6 might be, let me just make sure, because you said you wanted everything to go to your 3 children, but you also talked about your grandchildren. Do you want to carve something out for the grandchildren, maybe off of the top? And some grandparents say, yeah, we would like to acknowledge our grandchildren, or we want to make sure something goes directly to our grandchildren. Some parents with grandchildren say, yeah, let's give $100,000 to each of our grandchildren, and then everything above that can go to our children equally. And so if you do leave things to grandchildren and they're minors, then you'll leave it to a trust for them. Maybe designate their parent, who is also your child, as the trustee of that trust that's going to handle the $100,000 or whatever is left to your grandchildren. So we always got to make sure, if you have grandchildren, and then some people will say, no, we don't want to carve out anything for the grandchildren. Let's just leave it all to our 2 children, our 3 children. And they can use their inheritance to take care of their children. That's how we envision we'd like to do it, to take care of our family. All right. And then question number 7 is whether you left it all to the children, or whether you left something to the grandchildren, or whether you left something to people who are unrelated to you. Question number 7 is, do you want to leave the inheritance that you're leaving to your survivors, do you want to leave it to them outright or in trust? And maybe the first kind of subpart of that is when you think outright, we're thinking in a lump sum. Each child inherits $2 million. It gets, kind of dumped into their lap. Nothing wrong with that. Many children of people who plan their estate are very responsible. And so the parents say, yeah, no, they're great. I want to leave it to them in a lump sum. I don't want to put any restrictions on them. They're good. Nothing wrong with that. Other people will say, well, let's talk about what those options are if we don't want to dump it into their lap and we want to have it managed for them, at least for a period of time, so that it doesn't get blown. It really benefits them for the rest of their life. It's going to be a life-changing thing for them. So, these children are going to inherit 2 million, and it might be $200,000, it might be 5 million or whatever. So it really doesn't matter, whatever the number is. So if we do have a conversation about leaving it in trust for them, we have to have conversations about, okay, after you pass away, who's going to be the trustee, and kind of manage all of that inheritance for your child and dole it out to them over time under terms that we'll discuss. Maybe that trustee would be an individual that you trust, or it might be a corporate trust company that handles, sometimes the larger inheritances when you don't have an individual that you feel comfortable naming as the trustee. So lots of questions to be asked if you go that route of leaving an inheritance to a survivor of yours in a trust. Questions like when do they get distributions? At what point does this trust end and it gets turned over to them? Probably worth mentioning now, going back to the outright, leaving it to your children outright, and this is the parents who say, no, our children are good, they're grown, they've surprised us, they've done really well, they're really mature, they're financially responsible, let's just leave it to them outright. No, nothing wrong with that. When we have the outright decision, there's still a possibility that you may want to leave it to them in a trust, for bluntly speaking, divorce protection purposes. Because if you leave $2 million to Sally and she's 30 years old, if you leave it just to Sally, the moment that she inherits it, it's her $2 million of assets and hers only. But if she takes that inheritance and mixes it up or commingles it with other assets that Sally has with her husband or spouse, then if Sally gets divorced, she winds up losing some of her inheritance, likely. So what a lot of parents do, even when they feel like their children are very responsible, they'll leave Sally's $2 million inheritance or whatever it is to what I'm going to call the Sally Trust. Maybe they'll even name Sally as the trustee of that trust. Not put any restrictions on Sally, but by leaving Sally's inheritance to the Sally Trust, all of those inherited assets will remain in that Sally Trust for the rest of Sally's lifetime. Can Sally spend it? Yes. Can she take it out of the trust and make distributions for herself? Probably, because that's probably the way you'll set it up. And because Sally's the trustee, and Sally will probably set it up so that Sally will have the right to take distributions. But the idea, as long as those assets remain in that trust and don't get commingled, and leaving assets to the Sally Trust makes it harder for Sally to commingle those assets with other assets that Sally may have with her husband. So that if she does get divorced later, then she keeps all of her trust, and then Sally and her husband split other assets that they may have acquired during their lifetime. So outright to your heirs or in trust, if an inheritance needs to be managed for a survivor, managed by someone else as a trustee, always go that trust route. But if you say, let's just leave it to them in a lump sum, there's still a decision of whether you just leave it to them in their name or leave it to them in a trust that makes it somewhat divorce proof, even though you're not putting any restrictions on their ability to spend it. Okay, so that's number 7, outright or in trust. Number 8, who's going to handle all this after you and your spouse pass away? Some people, I think, mistakenly believe that all the assets just kind of automatically get divided after the husband and wife pass away. It doesn't work like that. You have to name somebody as the person who's going to handle this distribution, and this person will likely be in charge of selling your home if that's appropriate after you pass away, so that the proceeds of the sale can be divided up among all the heirs. This person might be working with your brokerage firm to determine whether investments that you own when you die need to be sold or just dispersed in kind. This person might even be in charge of selling your vehicles and having those proceeds dispersed to the appropriate heirs or beneficiaries. If you leave, and we'll talk about this will or trust thing a little later in the conversation, but if you leave your assets to your survivors through your will, which is the traditional way people think about leaving assets to their survivors through their will, then this person that you name is what's called typically what's called your executor. Maybe in your state, maybe it's called a personal representative, but let's call it executor because I think that's what most states call it. And most married people, they appoint their spouse as their executor, but we always name a backup to your spouse. We don't know which spouse is going to die first. So you name your spouse and then maybe you name an adult child or children or some other individual, or maybe a trust company as the executor to handle things after you and your spouse pass away. If, however, you leave your assets to your survivors through your revocable living trust, more on that in question 13, then this person that you'll designate is typically called the successor trustee of your trust. So again, they'll do things as long as your trust is funded. We'll talk about that later. Then they'll be able to sell your home, work with your brokerage firm, work with your banks, immediately disperse the assets to the trust beneficiaries without having to go through that court and lawyer involved probate proceeding. So I don't want to get into the legalities and the legal mumbo jumbo too much of executor versus trustee yet. I like to talk in layman terms and just say, who's that person or people that you want to be in charge of making sure that everything goes exactly like you've described, you've wanted it to go. So that is number 8. Number 9 is maybe it's a let's back up a second. So we've got what you want to happen after both of you pass away. You've said you've wanted things to go to your children this way. You even said you wanted some things to go to your grandchildren. You've talked about who's going to be in charge of making sure all that gets handled. We've talked about whether to leave assets outright to your survivors or in trust for survivors. We got all that covered. Now let's talk about what happens when one of you passes away. Again, speaking to the married couple. And I think most couples kind of assume that what's going to happen is when one spouse dies, the surviving spouse owns everything. But when we dig a little deeper, it's often not what married couples want to happen. So let's just talk about 2 different options that married couples have on how they're going to leave assets to each other. Let's keep it simple. Let's say married couple, John and Jane, have $5 million, and let's say it's all jointly owned by the 2 of them. Each one has an estate of $2.5 million. Let's say John dies first. So Jane still owns her $2.5 million of assets. What happens to John's $2.5 million? Yes, he can just leave it to Jane, leave ownership of it to Jane so that Jane continues to own her $2.5 million. She also inherits the ownership of everything that John had. Now Jane owns the entire $5 million and whatever it appreciates to, and she can do whatever she wants to with the whole, she can match the whole $5 million. That's what I'm going to call leaving ownership to the surviving spouse. Some married couples get a little queasy when we talk about ownership to the surviving spouse because what could happen? Well, you've all heard the scenario, maybe even seen it in your life experiences where if John dies and leaves ownership of everything to Jane, and yes, it's set up so that when Jane dies, it all goes to the kids or grandkids, however we discuss. But however, if John leaves ownership of his $2.5 million or his half to Jane, and Jane owns it all, but really with one signature, Jane can disinherit the entire family. There's when the first spouse to die leaves ownership to the surviving spouse, then there's really no protection in place for John's children to inherit anything when Jane later dies. So a second option, and this second option gives some married people some peace of mind. There is no right or wrong here. Everybody's job is to make some informed decisions. And so the second option is for when John dies first, for example, Jane keeps her $2.5 million as to John's $2.5 million. John has the option of saying, well, what are the options other than just leaving ownership to Jane? He could say, I leave my part of the estate, my $2.5 million, to a trust for Jane. Maybe Jane's the trustee of that trust after John dies. Maybe Jane has the right to make distributions to herself for her needs for the rest of her lifetime. And then when Jane dies, whatever's left in that trust automatically goes to John's heirs, John's survivors, John's children, whatever he designated. And Jane doesn't have the right to change who John's estate will go to after Jane dies. She only has the right to change where her part of the estate goes. So that does give the kids a little more protection from the surviving spouse making a stupid mistake, or that which might be living with someone or remarrying someone and attempting to leave the surviving spouse's entire estate to people other than the heirs of the first spouse to die. So that's a really important. That's why it's one of the 14 questions that you have to ask a married couple is what happens not only after both spouses die, but what happens when the first spouse dies. Occasionally you find a married person who says, yeah, if I pass away before my spouse might live another 10, 15, 20, 30 years. I'd like to see something go to my children if I pass away first. So maybe there's a conversation about that. All right. So we got that covered now. So far we've got covered what happens when one of them dies, what happens after both of them pass away. Next, we move into some of the what happens while you're alive questions. First one is, and kind of question number 10 in the overall scheme of things, is if at some point during the rest of your lifetime, you ever get to a point, illness, injury, Alzheimer's, dementia, stroke, whatever, you get to a point where you can't sign your name. You can't transact for yourself. Maybe you have an IRA that is in your name and something happens to you. You're not dead, but you're incapacitated and you're just unable to make your own financial decisions. Question number 10 is, who do you want to make it easy to be able to handle your money and your businesses and your real estate if at some point during the rest of your lifetime you can't handle it for yourself? Now, most people, they wind up deciding, especially if they're married, they'll decide, I want my spouse to be able to do that. That's very normal. That's very customary. But I've had a lot of circumstances where, dad gets incapacitated, he gets Alzheimer's, and he's got a car that needs to be sold on his behalf, or he's got a brokerage account or an IRA, and distribution needs to be taken. But because of his dementia, he's unable to do that, doesn't have the capacity to do it. And he did do a power of attorney years earlier, and he named his wife as the agent. I'm going to call it agent, could be proxy, could be some other designation. But he named his wife as his agent on his power of attorney, and he didn't name his backup. Well, now dad's power of attorney needs to be used. Mom, who is his agent, she died. And so we've got to go through the whole court, guardianship, interdiction, depending upon what your state calls it, proceeding, where it is an absolute mess, where it's a court proceeding, lawyers are involved, medical people are involved, there's court hearings in front of a judge. And so all of that guardianship stuff can be avoided if you have your powers of attorney in place, where you appoint not only your spouse maybe as your first agent, but maybe a name adult child or some other person as the alternate agent to your spouse, just in case you get to a point during your lifetime where you can't sign for yourself and your spouse is unavailable to act for you. So all that's really, really important. It's, virtually everybody, when they get their legal affairs in order, they put these powers of attorney in place. And then question number 11 is a similar question, but it has to do with health related matters. Who do you want to make it easy to make your medical treatment decisions? Maybe you're in a surgery in the future and you are unconscious and doctors need to talk to people about treatment decisions. Who do you want to be able to do all that? Again, married people often say, I want my spouse first. Want maybe, my daughter who's a nurse to be the backup to my spouse. So anyway, those are again, important questions that need to be answered as part of getting your estate in order. And then there's the what I just talked about in question 11 was some states call it healthcare power of attorney, some states call it advanced healthcare directives, some state call it healthcare proxy. So all this, who do you want to make your medical decisions if you can't make them? And in some cases, you might even specify your kind of treatment decisions, check off certain things based on kind of what's customary in your state. But then there's the separate healthcare matter. I'm going to call it the living will. It's that statement about life support machines. It's not necessarily where you appoint someone to make that decision for you. If you have a living will or statement about life support machines, what many people do when they make that decision, they don't appoint family members or trusted loved ones to make that decision. They make their own decision. They document it. They direct that their family and their doctors honor those wishes so that that life support decision usually goes something like that. If people sign a living will, they usually sign something that says, look, if I'm in that profound vegetative state and there is no reasonable chance of recovery, maybe if it goes on further to state that if two physicians, maybe one of whom is your attending physician, certifies in writing that you're in that profound vegetative state and there is no chance of recovery, then by signing a living will, you're not appointing family members, but you're making your decision. You're the patient. You have the right to make the decision. The living will is where you're able to make that decision in advance. But if you are in that vegetative state, no chance of recovery, machines just artificially prolonging the dying process. By signing a living will, you're typically making your decision, directing the medical care providers to withhold or withdraw the life support machines, but keep you comfortable, and you're directing that your doctors and your family honor that decision. So living wills are binding. The idea behind the living will, as many people realize, is that it relieves your loved ones, your surviving family members, from the burden of having to make that one final decision to end life. Many people have talked to me in conversations and said, yeah, my father had a living will and he was on life support, and it sure made it easier for us that dad had signed his living will. We knew what he wanted. It just makes that whole process much easier. So there's question number 12 is let's have that living will conversation and see if you want to express that in writing. All right. And then question number 13 is, okay, we've talked about all of this. Who's going to handle things when you're incapable? What's going to happen if you predecease your spouse? What's going to happen if you're the surviving spouse and then you pass away? All of the who's going to inherit, who's going to be in charge. We probably talked through some tax consequences of all of that: estate tax, income tax, capital gains tax. So question number 13 is, how do you want to do all this? Because you've got a couple of different options and a couple of different ways to do it. And I call it, one way you could do it is through what I call the will plan. The other way to do it is through what I call the living trust plan. So some people, say less than a majority, some people opt to go the will plan. That's the traditional, customary, kind of the old-fashioned way that people would get their affairs in order. They would leave all of their home, their business, their shares of stock, their limited liability company membership interests. They just leave everything in their name. And they rely on their will to provide who inherits when they die. They may even include some trusts in their will called testamentary trusts that say, I leave $2 million to Freddie, but that $2 million is going to be in a trust, and so is going to be the trustee, and here's the trust terms under which Freddie can access that $2 million. So some people leave their assets to their survivors through their last will and testament. Of course, they also have the powers of attorney and all that. Those are separate. But I call that the will plan. What people don't like about the will plan is if you die with assets in your name and you rely on your will to provide for the disposition of those assets to your survivors, then your survivors, when you pass away, are going to have to hire lawyers, go through a court proceeding, and have courts and judges involved, because for some reason, many years ago, I guess hundreds of years ago, it was determined that our court system would oversee the distribution of someone's assets that they owned when they died. So if you die with assets in your name, now things are frozen and survivors hire lawyers lawyers work with the courts and the judges oversee this settling of the estate process and this distribution of the assets to the survivors. And most people complain because that is a less than efficient system, taking months or years. Costs are kind of through the roof, and because you're hiring lawyers and going through a court process. So many people, I would say a majority of people who are serious about getting their legal affairs in order, probably a super majority of people who are serious, who have built an estate and are serious about trying to make things easy for their survivors, they'll opt for that living trust plan. The idea there is John and Jane set up their John and Jane Doe revocable living trust. They transfer their home from John and Jane Doe to John and Jane Doe as trustees of the John and Jane Doe living trust. They transfer their LLC membership interest. They transfer maybe their brokerage account. They transfer other real estate that they own. They transfer all that from John and Jane to John and Jane as trustees of the John and Jane Doe Trust. And then the trust has all of those. What happens if they're incapacitated? What happens when they die? Who inherits the trust assets? So the trust governs all of that. And the idea is that things that are already titled in the name of your trust when you die, they don't have to go through all of that court and lawyer involved process. So if you have your living trust and you name your son as the trustee to handle things after you and your spouse pass away, and you leave the assets to your three children equally, the three children are what's called the beneficiaries. Sometimes they're called the principal beneficiaries of your trust. And really the day after you and your spouse pass away, your son as the successor trustee, he can put a for sale sign in your house and sell your house the next day, and then divide up those proceeds among your trust beneficiaries. With your death certificates, he'll go to your brokerage firm. They'll give him the ability to access those investments, divide that up three ways if the three children are the trust beneficiaries, all outside of that court and attorney involved process. So quite frankly, I've set up many living trusts for people, and sometimes I find out when they pass away, either because I kind of knew them or word might get back to me. But I never hear from the survivors because the legal, the lawyer isn't necessary in many cases to sell the house, to access and divide up the brokerage account, to transfer or wrap up a business or an LLC. So, of course, if those things are in an individual's name and it's got to go through probate, then I hear about it every time because we have to do a lot of legal work to take that estate through the court process. So most people like the idea of setting up that living trust to keep things simple for the survivors and avoid all that court and lawyer involvement. So that's question number 13. How do you want to do all this? Do you want to do it through your will plan or through your trust plan? A couple of notes: under either plan, you're still going to have all the power of attorney, healthcare stuff, living will. And then if you have a trust plan, you'll also have a will called a pour-over will. It may never be used. It's only used if when you die, there's something in your name that didn't get into your trust while you were alive. So we've got to use the will to go through the probate. And that will says when I pass away, if I own anything in my name, I leave it to my trust so it can all be dispersed by the trustee to the trust beneficiaries. All right, and then maybe the 14th and final question, again, probably just as important as the first one where I asked you what you wanted to make sure you accomplished. But my 14th and final question is there anything that I didn't bring up that you wanted? Maybe it was on your list, maybe it was on your mind, but is there anything we didn't talk about that you wanted to make sure that we talked about? And so, the better the job the lawyer did guiding you through these and asking you the right questions, the less likely there's going to be some further questions on the back end when you're asked, is there anything that we haven't talked about that you wanted to make sure we covered? And so, a lot of times the answer to that question is like, oh, let's see. We talked about when one of us died. We talked about after what we both died. We talked about taxes. We talked about power of attorney. We talked about who's going to handle this stuff. We talked about how I'm going to take care of my wife. No, I think we've talked about everything that I thought we should talk about. So that's the 14th and final question. Is there anything you feel like we haven't discussed that we should have discussed, or you thought we would discuss, or you wanted to discuss that I didn't ask you about. So always, want to make sure all the head is clear and everything that needed to be addressed. Okay, so obviously there's 14 questions. The 14 questions I'd say typically turns into maybe 50, maybe 100 questions based on your answers to those questions. So let's jump right in. We're always saying, Susie, we see you every time, and it looks like Randy or Renwolf, we see you every time. So from Colorado, beautiful state there. All right, good to see you. And Jalen, good. Sarah, I called it. They do that. How often do we need to update our state documents if they've been previously done? Good question. So that's a really good question. So let me take a minute and address that. How often do we need to update our state documents if they have been previously done? So, well, my lawyerly answer, of course, is it depends. So I would say there isn't a hard and fast rule of update your documents every 3 years or update your documents every year or even every 5 years. So I've had some circumstances where I created an estate plan for people 30 years ago. And I'll talk to them 30 years later, and there's no reason to change anything because their family circumstances haven't changed. They still want to leave things to their spouse and their kids the same way. All of their appointments are still what they had before. I will tell you, though, sometimes on the power of attorney side, a lot of third parties, financial institutions, they don't like dealing with a power of attorney that's 30 years old. So maybe it is appropriate to update those periodically every several years. Again, no hard and fast rule, but always if we're updating something and it's been 10 years since we did something originally, we tend to always update those power of attorney documents to keep them from being really old. They don't expire. It's just, I think banks get nervous when they're presented with a power of attorney for someone and that document is, 20 or 30 years old. So now I talked to someone today who said we did our stuff not too long ago, but we're moving because of our job. We're moving to Virginia. And she said, oh, by the way, when we did this, our kids were minors, our family circumstances have changed. So probably warrants getting things updated. Obviously, if you've had a change in your intention or your life circumstances. Again, maybe you did things a certain way when your children were 4 years old and now they're 34 years old. All those designations where you would have never designated your young children to have certain roles in your estate plan in the future. Now you may want to update that stuff because your children are adults and they're responsible and they can have certain roles as part of your estate plan. Or you just want to change. Maybe before you left things to your children equally. Now you've got some grandkids and you want to carve some things out for the grandkids. Maybe now you want to do some charity stuff. You want to leave something to charity. So any of those kinds of decisions that you make is a reason to update your estate plan. So some estate plans need to be updated 6 months after they were previously done because there was a change in family circumstances. Sometimes years can go on after somebody creates an estate plan and really no updates are necessary. So good question, Sarah. All right, major life changes. Yeah, deaths, moving state. Okay, you said moving state, which was one of those, which was the example I had today. So yeah, death is often, if you named your spouse as the first person to handle lots of things for you and your spouse predeceases you, we always update certain things to kind of move other people up in the chain. People get divorced, and so another reason to change things. So good question, Sarah. Hey, Paul, what are your thoughts on titling vehicles in the name of revocable trust? Thanks for all the great info. Yeah, boy, that's James. That's a state-specific question. I'm going to start broad and get narrow. The broad answer is many states are passing legislation to enable people to title things, whether it's their home, whether it's their cars, whether it's their LLCs that they have. States, you're finding, are starting to pass legislation enabling people to title assets. We saw it with the bank accounts, with the payable on death. We saw it with the brokerage accounts, with the transfer on death. That's been around for a long time. Now we're seeing states start to pass legislation where people can title things and designate who gets those assets when the owner passes away. Not every state has done it for vehicles. Not every state has done it for LLCs. Not every state has done it for homes or real estate, but some states have. So it's really a state specific question. If your state does allow you to title your vehicle so that a certain person is entitled to own it when you pass away, and that's all done on some Office of Motor Vehicle form, then maybe it's not necessary that you actually retitle your vehicle in your trust. Um, and then some states, for example, I know in Louisiana, it's if a person has owns vehicles in their name when they die, and under certain circumstances, if there's a provision in their will where they leave their vehicles to certain people, then after you die, those persons who are entitled to own your will, own your vehicle in because they're designated in your will, they can bring just a photocopy of your will and your death certificate to the Office of Motor Vehicle. And again, the Motor Vehicle Office will transfer those vehicles again outside of probate. But so we have to look at each state and see what each state requires and then make a determination. Do you keep your vehicle in your name or do you retitle it to your revocable living trust? Certainly no harm in retitling it to your revocable living trust. And if you do that, I would suggest contacting your automobile liability insurer and get your trust added as an additional insured. It won't require any kind of new insurance policy or increased cost, but good to do that. So that's the state by state thing. Let's see, what type of trust would you do to protect the assets from creditors and nursing homes? So that's maybe Chelsea. We didn't talk about that much today. We did talk a lot today about transferring your assets to a revocable living trust in order to make things easier on your survivors when you pass away, because things that are in your trust, they avoid having to go through that court and lawyer involved probate proceeding. But transferring your assets to a revocable living trust doesn't help or hurt your creditor or nursing home protection status. That requires other kinds of trusts or other kinds of transfers, really beyond the scope of this video. But I will tell you, it is common for, you know, you talk about creditors and nursing homes. So just a very, very quick entry into that. Um, so what you can't do is have your cake and eat it too. Some people want to um, protect their assets in case they get sued, but they want to maintain complete control over those assets while they're alive and while they're not getting sued. But the whole idea behind this kind of lawsuit protection, I don't want to get into it too much, but you have to give your assets to others or put them in trusts for others where it's not your assets anymore. And you don't have the ability to get at them. So if you don't have the ability to get at them, then your creditors don't have the ability to get at them. It's kind of similar for nursing home purposes as well. So that's the quick version there. All right. And so appreciate you if, thank you. If outside the will, is that still part of the estate legally? Oh, that Shannon, I guess, is going to require. So if you have assets that are outside the will, I'm thinking that's maybe an IRA, 401k, maybe an annuity, maybe a life insurance policy. So the typically, if you have an IRA and your spouse or your kids are your designated beneficiary, the will has no say so in regard to where that IRA goes. I guess the will would have say so if you left your IRA to your estate, and then your will would govern who gets your IRA. But that's rare, and very rarely does that make sense for people to do that. So most people name individuals as beneficiaries of their IRA, their life insurance, their 401k, their annuities. So you're asking, is that still part of the estate legally? Well, we have to define estate. Is it part of the probate estate? For the reasons I just expressed, no, it's not part of the probate estate where lawyers and judges and courts have to get involved in the transfer of the IRA to your designated beneficiaries after you pass away. But Is it part of your taxable estate for purposes of what's in your estate for federal estate tax purposes? And the answer is yes. So if you own an IRA, it's not part of your probate estate, doesn't go through the court process to be transferred to your beneficiaries. It's a non-probate asset. It's not part of your probate estate. But if you own an IRA when you die, is it part of your estate for federal estate tax purposes? Yes. You add up the value of everything the person owned, regardless of whether it has to go through the probate estate or whether it goes to designated beneficiaries. That asset, when you died, it is part of your estate for federal estate tax purposes. Okay, so great question there, Shannon. Hopefully that clarified some things. You're welcome, Jane. And we've got Shannon with the old emoji with the waving hands, which I like to see every time. Okay, stay tuned. Lots more to come. We'll see you next time.